Hello and welcome back to our channel. Today we're diving deep into a legal battle that could reshape the boundaries of public information in Indonesia. It's a story that touches upon the highest offices of the land, involving a long-running controversy about the academic qualifications of public officials, including President Jokowi and Vice President Gibran. At the heart of it all is a fundamental question: should a public official's diploma be considered a public document or a private one? Let's break down the recent hearing at the Constitutional Court, or MK, that's tackling this very issue head-on. The courtroom drama began with a judicial review hearing for Law No. 14 of 2008 concerning public information disclosure, often referred to as UU KIP. The petitioner, an attorney named Komardin, stepped forward to challenge what he sees as a critical ambiguity in the law. He argued that the current wording has caused significant national unrest and confusion, particularly regarding the academic records of state officials. You might remember the widespread online debates and polemics questioning the authenticity or existence of diplomas belonging to various figures, which have been circulating for years. Komardin believes the root of this problem lies within the law itself. His legal challenge focuses specifically on Articles 17 and 18 of the UU KIP. These articles are crucial because they define what kind of information is excluded from public disclosure. Article 17, for instance, lists several categories of information that must be kept confidential. This includes information that could hinder law enforcement, disrupt national defense, harm foreign relations, or reveal business secrets. It also protects personal information related to family history, medical records, financial status, and other private data. This is where the debate gets tricky. Is a diploma, which is a record of personal academic achievement, covered under this personal information clause? The law doesn't explicitly say yes or no, leaving it open to interpretation. Komardin argued that this lack of clarity has created a constitutional loss for citizens. When the public requests access to a public official's diploma and is denied on the grounds that it is private information, it fuels suspicion and erodes trust. He pointed out the recurring controversies involving President Jokowi's and Vice President Gibran Rakabuming diplomas as prime examples of this national unrest. He contends that these disputes wouldn't escalate to such a degree if the law provided a clear answer. The ambiguity, he claims, allows for a situation where public officials can shield their academic history from scrutiny, while the public is left to speculate, leading to misinformation and political instability. The petitioner's goal is to force the court to clarify whether a diploma, a document that often qualifies someone for a public role, should indeed be open for all to see. During the preliminary hearing, the panel of constitutional justices listened intently. But it was Constitutional Justice Arsul Sani who provided the most critical feedback, offering a piece of guidance that could make or break the petitioner's case. Justice Sani, a seasoned legal mind, drew a sharp line between two distinct legal concepts, challenging the norm of a law versus challenging its implementation. He cautioned Komardin that his argument seemed to be more focused on the implementation of the UU KIP, that is, how public bodies have been applying the law rather than a flaw in the norm or the text of the law itself. Let me explain this distinction because it's vital. Challenging a law's implementation means you have a problem with how an agency or official is interpreting and enforcing the rules. For example, if you believe the Ministry of Education incorrectly denied your request for a diploma, your legal remedy would be to file a complaint with the Central Information Commission or take it to the State Administrative Court (TAN). These bodies are designed to handle disputes over the application of existing laws. On the other hand, challenging a law's norm means you believe the text of the law itself is unconstitutional. You're arguing that the words on the page are inherently flawed, vague, or contradictory to the principles of the Constitution. This is the exclusive jurisdiction of the Constitutional Court. Justice Sani pointed out that Komardin's petition heavily cited instances where information requests were denied. This, he suggested, sounds more like an implementation issue. He strongly advised the petitioner to refine his arguments during the 14-day revision period. The challenge for Komardin now is to reframe his case to prove that the problem isn't just that officials are making the wrong call, but that Articles 17 and 18 are so poorly written that they inevitably lead to these conflicts and constitutional harm regardless of who is implementing them. He needs to demonstrate that the text itself is the source of the legal uncertainty and public unrest. This guidance from the court is pivotal. If Komardin fails to make this distinction clear, his case could be dismissed on procedural grounds for being misdirected. He must show that the ambiguity in the term personal information within the law is a constitutional flaw that only the MK can fix by providing a definitive interpretation. For instance, he could argue that because holding public office is a matter of public trust, the academic credentials used to secure that office cannot be considered purely private, he might propose that the law needs to be amended to explicitly state that diplomas of public officials are public information, thereby removing the ambiguity once and for all. The implications of this case are enormous. If the Constitutional Court sides with the petitioner and rules that diplomas of public officials must be disclosed, it would set a new precedent for transparency in Indonesia. It would mean that any citizen could request and receive the academic records of their elected leaders and high-ranking civil servants. This could help settle disputes like the ones surrounding Jokowi and Gibran and prevent similar controversies in the future. It would arm the public with a powerful tool for vetting candidates and holding officials accountable for their stated qualifications. Proponents would argue this is a victory for democracy and good governance. However, there's another side to this coin. If the court rules against the petitioner or maintains that diplomas fall under protected personal information, it would reinforce the current status quo. Officials could continue to deny requests for their academic records, citing privacy concerns. Opponents of disclosure argue that a diploma is a personal document and that forcing its release could open the door to harassment and misuse of personal data. They might contend that there are other ways to verify qualifications without making the physical document public. A ruling in this direction would reaffirm the line between a public figure's public duties and their private life, placing academic records firmly in the latter category. This case forces us to weigh two competing values: the public e's right to know versus an individual e's right to privacy. Where do we draw the line when the individual is a public servant whose position is funded by and accountable to the people? The outcome of this judicial review will have a lasting impact on how we answer that question in Indonesia. It will define the legal landscape for transparency and public scrutiny for years to come. Will the court decide that the secrecy surrounding these documents is a bigger threat to the nation than the potential invasion of privacy? Or will it find that the existing law, despite its ambiguities, strikes the right balance? As we wait for the petitioner to revise and resubmit his case, all eyes are on the Constitutional Court. This is more than just a technical legal argument. It's a reflection of a society grappling with the demands for greater transparency from its leaders. The Ijazah controversy has been a recurring theme in Indonesian politics, and this case could finally provide a definitive legal resolution. We will be following this story closely and will bring you updates as soon as the revised petition is heard. What are your thoughts? Do you believe public officials' diplomas should be public information? Let us know in the comments below. Thank you for watching. If you found this analysis helpful, please give this video a thumbs up and don't forget to subscribe to our channel and hit the notification bell so you don't miss our future updates on this and other important legal news. Stay informed and see you in the next video.